Every Wednesday, we're going to be talking about stuck abroad, how waivers can bring you back in 2025. Now, of course, we know there's lots of changes going on. We're recording this around the end of June 2025, so things can constantly be changing. Um, it might sound, there's a lot of going on right now, and what we really want to say is that there may or may not be a way to come back to the United States, and we're mostly talking about immigrant waivers with a little bit of a non-immigrant waiver mention. So I'm board certified immigration attorney of the firm Powers Law Group here in Houston, Texas, but we help people all around the world on U.S. immigration matters. So there's travel bans of the 19 countries, some partial and full with exemptions for green card holders, some other individuals, and then we have potential travel ban for 36 other countries looming. There's a high number of detention, like 55,000 people detained right now, over 140% um, over capacity. So there's a lot of things going on. And so let's just go ahead and talk about what we could possibly do. So I've been doing waivers since I became an attorney in 2008. And some attorneys do them more than others in immigration space. It can be very complex, and really a lot of it comes over time being able to spot things and trends and see things. One of the important things to note is that we have to scan for any inadmissibility, real or perceived. And what that means is maybe it really exists, and maybe it's just maybe the USCIS might make, or consulate might make that finding. And then you check to see if there's an immigrant or non-immigrant visa waiver available, and then potentially apply if and assess if you even would qualify. But you also need to have a visa available as well. So this is just assuming that you have a visa. And for example, married to a U.S. citizen, that's an immediate relative, but doesn't mean that the visa is going to be the I-130 could take a year and a half. There's some other things like a brother-sister petition that could take a really long time, like maybe 20 years or so. So we're really talking about being able to have the visa available to do these things. Um, so that is something that you have to think about when you're processing these, and we can go from there. So let's go ahead and continue to mention the next steps. Um, Now, there are different types of waivers, so sometimes people get confused by all of this. So there's I-601. It's used, you can file it in the United States or abroad, but it is used for like fraud, unlawful presence, crime, things like that. I-601A is the provisional waiver that came out in 2013. And this one is where if you only have unlawful presence and you are in the United States. The due 212 form, and this is the form, is mostly a deportation related waiver for expedited removal, deportation order, or after you've been out the country for 10 years and you're after a permanent bar and you're wanting to come back in. And there's also the 212 D3 waiver. Sometimes people just call it the D3 waiver for non-immigrant visas. And this is more common for like the whole DACA switching over to maybe H-1B or something along those lines. So the I-601 form can be for lots of different inadmissibility issues, including like crimes involving moral turpitude, multiple criminal convictions, and those types of things. So that form could be used for many different things, as well as unlawful presence, misrep, etc. Those are the two that normally the most common: unlawful presence and misrep, but it also can be used in this other criminal matters we're mentioning. The provisional waiver is only for unlawful presence, and it's more of like a cleaner type of a case. And that was came out in 2013 under Obama, and it's allowed a lot of people to be able to stay in the United States and process. But you have to have a U.S. citizen or legal permanent resident spouse or parent who would have the extreme hardship. And the I-601 form really depends on which inadmissibility that you're addressing, what qualifying relative you need. This is even complex when I'm explaining it to lawyers or attorney students in law school. So I'm just trying to keep it a little simple. But the idea is, let's think outside the box here, go back out, zoom out. You need to have the visa available. If you have any inadmissibilities, you need to be able to have qualify for a waiver for that one. And you have to have it, depending on what you did and how you did it, you might be doing the I-130. Then let's say if you have to leave the country or you're deported or what happens, you might need an I-601 for unlawful presence, an I-212 for deportation, something like that. So there are different waivers and or different things, and really would require us to evaluate your case. But I think we're going to get to the point where we're going to be helping people get back in the country soon, after this administration and all the high detention, what's happening right now. So again, the I-601 form can be used for lots of different things, but if it's for misrep and unlawful presence reasons, then you need to have a U.S. citizen or legal permanent resident spouse, parent, or U.S. citizen fiance, and the standard is extreme hardship. The I-601A, again, the U.S. citizen or legal permanent resident spouse, parent, or U.S. citizen fiance, extreme hardship. The provisional waiver has been very helpful, but unfortunately, the processing time is very long. So what would usually happen is the I-130 would get approved after about a year and a half. Then we would do the provisional waiver, and then while the provisional waiver is pending, we could do the National Visa Center. The provisional waiver is taking about 37 to 43 months. It might be a little bit faster, but we're not sure how long it's really going to take. And then once you get the visa appointment, then you leave. But you have to screen all along the way to make sure. If you leave a little bit early, we have to evaluate if you have any more inadmissibilities, because if you have more than just the unlawful presence issue, then you wouldn't be able to use the I-601A, even if it had been approved. If it was approved, but you need other inadmissibilities, it would help to show that you previously did meet the standard, but you would also you still would need other waivers if you have more inadmissibilities. The I-601 is used when you go, you can file it with an adjustment of status, but we're really focusing on the cases if you happen to be outside the country and you're trying to come back in. They could make the finding at the consulate, and then you would have to submit the I-601 waiver. Now, the I-212 form waiver, it can be filed inside the US or outside, but it can be used for lots of different reasons. And what I mean outside, you could be inside or you could be outside, but expedited removal, it really depends on the situation because it's used for lots of different reasons. Expedited removal bars you for 5 years. So if you've been out for 5 years, you wouldn't need it. The deportation, there's the deportation for 10 years. The permanent bar reentry means you have to stay out for 10 years and then get this form to get back in. Yeah, the reentry after removal as well. So this is a separate form. The D3, there was some guidance about that there was a more expansion, availability. It's gotten a little bit quiet more recently under the Biden administration. It's really important to have an immigration attorney because all of this is complex. You might say, oh, I could try to figure it out. Well, the thing is that you don't want to make a mistake, especially because of how much money and time is put into this. And then if when you finally get an appointment, you want to make sure that you're ahead of schedule and you have what you need to go forward. So we do this all the time. So we're able to screen, we're able to find what could be an issue, whether you're eligible, and we can try to minimize any rejection of files or other inadmissibility findings and issues like that. So that's one of the really good reasons to have an attorney. So really what we're doing is we would be identifying any admissibilities, making sure that you have a visa available in the first place. Is it an immigrant or non-immigrant visa? Then we would decide to go forward with what waiver you might be eligible for, then collecting evidence, double checking the fees that are needed. And if you, depending on where you are in the process, if you left already, what needs to be done, if you had something in the process. So this is all a part of what we would help you do, or you need to, and I'm trying to put a lot of information in the short of the webinar. And the big points would be have an attorney, experienced attorney, screen, make sure you have a visa available, and know that this could be the long haul of processing because of how long some of these I-130s and waivers take. So you just want to stay calm, find opportunities. Maybe you want to go to another country while you're waiting to get back into the United States. You could try to ask for expedited processing. In our experience, it's been very difficult to get that approved right now, but in extreme circumstances, you might need to be communicating also with the consulate, and definitely don't re-enter illegally, as that could cause a permanent bar. Now, the I-601A, like we said, is taking like about 3 years or so. I-601, we've been seeing it's taking a while. This is definitely an issue, especially when our clients are outside the country waiting for it. But definitely consult an attorney who does this on a regular basis. And review before we send anybody abroad. If we have control over that, we make sure to screen, and double check they're eligible all along the way. So my name is Ruby Powers. Here at Powers Law Group, we're here to assist you through this journey between immigration and consular processing and waivers and admissibility. This is one of our fortes here at Powers Law Group. So you can find us on Facebook, Twitter, Instagram, TikTok, Blue Sky, and we have a newsletter that comes out in English and Spanish every week. So this is towards one of our June webinars, or hope you enjoyed it and found some value. Please feel free to share with a friend, loved one, neighbor, someone you know who could benefit from it. But also know that we provide this as well in Spanish. So hopefully this was helpful, and we'll see you next time. You can reach us at 713-589-2085, 713-589-2085. And you can also schedule consults on our website, rubypowerslaw.com, rubypowerslaw.com, directly on the consultation tab. Thank you.